Hello everybody. So today's discussion is going to be on when to use an advocate. So I'm often asked, what is my personal background? Why is it that I am qualified to be an advocate? Well, first and foremost, my occupational background is 22 years of restaurant management experience, as well as teaching 8 years at Long Beach City College in their hospitality tourism program. In addition to that, I have a master's in business administration from the University of Redlands. And as a combination of all of those various traits, I am qualified to be a professional in the area of hospitality and tourism. However, when my son was diagnosed with autism back in 2005, I had to make a choice. I had to make a choice as to whether to stay as a restaurant manager or whether to take care of my son, because when my son was first diagnosed, his conditions were fairly serious. We got regional center services, and I started to go to various parent groups, and it was at a group in Riverside at a function called the Speech and Fun Camp that I first learned myself about protective supervision. And then after learning it myself, I of course went online and did as much research as I possibly could. And I learned all about the program, and I applied for my son, and when my son was 4 years old, we got protective supervision. And after getting protective supervision for my son, I did what I thought was the appropriate thing to do, and I of course became a focal point for passing on information about IHSS protective supervision to other parents. And I would do presentations at various functions, like the following year's Speech and Fun Camp, for example. And I would have a group of 40 to 50 parents in a room, and I would get them all pumped up about protective supervision. And then what I quickly learned was that they would go and they would get on the phone and they would apply for IHSS on the phone, and they would be denied themselves over the phone, and they would stop. And so given the fact that the function that I was doing these presentations at was typically during the summertime, it wasn't until the following year that I learned that one of the families that I was all excited about helping had called up IHSS and had attempted to apply and were denied on the phone, and they had stopped themselves. And that was when I had my aha moment. What if I actually was the one that actually did the legwork for these families? Because obviously, for whatever reason, they were having a block in getting to where they needed to go to. And so we formulated IHSS Advocates. And since we formulated that over the last 10 years, because we started in 2010, we've overturned just shy of 600 denials over the 10-year period. I educated myself on the ins and outs of the system to get approval for my son. My son was my very first approval, and since then, like I mentioned, we've done this for hundreds of other families. At IHSS Advocates, we encourage parents and caregivers to go through the steps of approval themselves for protective supervision. They should apply on their own, and they should only seek out an advocate if in fact they are denied with a notice of action. We started forum groups like this Facebook group to assist parents and caregivers like yourselves in order to be able to navigate the process for protective supervision. Unless there is a formal denial with a notice of action, we do believe, as stated before, that this is something that you should try on your own. You should only use an advocate if it puts you in a place that is better than where you are currently at. Some advocates can be financially more feasible than others. With us personally, the cost of utilizing IHSS Advocates to overturn your denial is less than 4 months of your soon-to-be newly acquired benefits. So it actually is very reasonable, and considering the fact that in most cases there is approximately 8 months worth of retro by the time we actually get approval, it ends up being a situation where after paying our fee, there's money left over for the family, and then going forward, the benefits are completely theirs. Please consider that the fee that you get when you get retro is money you don't currently have. We as advocates have a vested interest in helping you obtain this benefit. If you're not successful in overturning the denial, at least with IHSS Advocates, you don't pay a fee because we are contingent. So we try to make this as painless as possible. As my partner David Wolf often says, it's almost like it's not out of pocket at all because it comes from money that you currently don't have at the moment. Well, I also want to make sure that everyone understands that the program is designed for the layman. It's designed for individuals who are not attorneys. And I say that, and there's a couple of points I want to present so that you understand exactly why I'm making this statement. The administrative hearing process is designed so that the judge has a responsibility to develop the record. That means that the judge has the responsibility to make sure that every single possible fact that might impact the acquisition of hours is heard at a hearing. It's not the burden for the claimant, it's the burden, quite frankly, for the judge to make sure that the claimant's all of the concerns are addressed at the hearing. And I'm not just talking about protective supervision, I'm also talking about things like bowel and bladder care or dressing or feeding or bathing, oral hygiene, grooming, paramedical, all the IHSS hours. If there is a potential need, the ALJ is supposed to explore that at the hearing. I wanted to also point out that if we are unsuccessful in persuading an ALJ to grant protective supervision in our cases, we do use a handful of other professionals to help us overcome those obstacles. I wanted to make a couple of mentions here to some specific. First one is, in terms of IEPs, we recommend Mira Amster, the Amster law firm, in overturning IEPs and in terms of achieving objectives with school in mind. I actually spoke to her yesterday, and she wanted me to mention that she actually thinks that age 3 is a really good age to explore school options. She mentioned that one of the things that she likes to do is she likes to get families into placements that are designed specifically for the child, but they're paid for by the school district. So that would be schools like non-public schools, perhaps like the Help Group and organizations like that. And so that's what she specializes in. But in terms of IHSS, the reason why you would want to work closely with an IEP advocate, in addition to potentially an IHSS advocate, is because a lot of times there is language that's missing from your IEP in terms of behaviors in the classroom, in terms of need that's documented in the IEP, in terms of observations by the teacher. There's a lot of times a lot of items that are left out of IEPs, and if you use a professional like Mira Amster for the IEP, that would help you to be able to ensure that the language that's necessary for achieving not just a better placement for your child in school, but also other programs like IHSS, it would help you make sure that those functions are met. I also want to indicate too that as an advocate, I myself personally am not able to go to Superior Court. So for those times in which we have a denial and the denial goes to a rehearing and the rehearing is denied, we still have an option to go to Superior Court. And for that function, I wanted to also indicate that we use the law office of James Diskant. Formerly, we were making our referrals to Charles Wolvinger, except that Mr. Wolvinger retired last year, and so Mr. Diskant is filling the role of Mr. Wolvinger in assisting advocates in obtaining writs in Superior Court when necessary. And I wanted to emphasize, as stated before, the administrative hearings process is designed to be for the layman. It's designed to be for the average person to be able to present their case. And the reason why you would use an advocate in administrative hearings is because we package your paperwork together and make sure that the documents are presented in a format that's easy for the ALJ, the administrative law judge, to understand, but also we focus on the applicable statutes and regulations to make sure that your concerns are heard. A lot of times, even though the ALJ has the responsibility to develop the record in an administrative hearing, information is left out, whether it's because the claimant doesn't realize that a certain document might be relevant, or perhaps maybe they're nervous and they forgot to mention a certain behavior that they're concerned about with their child. When you use an advocate and the advocate goes over all the documentation beforehand and packages it together with a very thorough position statement, and then a skilled advocate on top of that actually presents your case at administrative hearings, you have a higher likelihood that these miscues won't occur. The reality is that all of us are humans, and even though the administrative hearing process is designed for the layman, you're going to have a higher success rate if you use somebody who has done this quite a few times versus if you try to do it for the first time yourself. So once again, I wanted to say that in terms of when to use an advocate, we do endorse the concept of self-advocacy. That's why we have all of the generic resources that we provide, including this group. But there are times in which it is better to use an advocate versus to try it yourself. If you're ever at a point in which you are going to give up and not go forward yourself, absolutely, 100%, that would be a perfect time to use an advocate, especially one that is contingent, because that is an opportunity where you have a chance to at least share your retroactive benefits with a skilled advocate instead of getting zero because you've stopped altogether.
Okay.
Questions?
So actually, Larry, I'm sure you addressed this already, but we had a pre-question from Richard Thompson. Is there ever a time a provider would need help from an advocate?
Absolutely, yes. So IHSS is assessed every single year. And so just because you're approved for IHSS in the current year's matter does not mean that the matter will not be reversed the following year. In fact, I actually have personal knowledge of a handful of cases in which the provider who was granted protective supervision, say in 2019, in 2020, a new social worker has come out and they've attempted to take the benefits away. So yes, in the event that in the following year that the benefits are being taken away, that would be a reason why you'd use an advocate. In the case of IHSS advocates, with me personally, the agreements that we actually enter in with our clients are 3-year contracts, which means that we don't just get your benefits up front. We also ensure that the benefits stay in place for 36 months, for 3 years. And it's for that reason in particular. There's been multiple occurrences in which a family has been approved at, say, when the child's age 3, and then a second social worker comes in the following year and tries to take it away for various reasons. So yes, it is possible that you would need to have an advocate even though you've already got services.
Okay. George Stevens says, if you lose an appeal, is it worthwhile to have a rehearing? Do rehearings overturn ALJ decisions very often?
So with us personally, in the year 2020 going into 2021, we have seen a significant decrease in the amount of rehearings granted. Whether that is something to do with the pandemic, I could not tell you. We've also seen an increase in denials. Now keep in mind that my organization focuses with very young kids. So I'm focused with the kids that are age 3 to 5. And so the reasons why I've seen denials recently has to do with the fact that the judges have made some opinions that are, in my opinion, contrary to either policy, procedure, statutes, regulations, court orders, or published clarifications by CDSS. And so the reason why you would take that type of a matter beyond a rehearing is in the event that the rehearing unit indicates that the matter is something that would not be granted a rehearing because they make the finding that the judge used appropriate evidence or there is not substantial documentation to reverse the ALJ's decision. If you go into Superior Court, you actually have the opportunity to have a third party that's not affiliated with CDSS hear the matter. And so it's more formal. As I mentioned before, when you go to Superior Court, when you file the writ, it does require an attorney. And when that happens, The judge will make one of three determinations. The judge will either uphold the previous ALJ's decision, which would be you're still denied on your case, or the judge could grant you approval outright, or the judge could order the case to be remanded back to administrative hearings. And that would be if the judge determines that there was an error in discretion, but that there's not enough evidence to determine whether protective supervision or whatever the hours that you're claiming should be granted. And those would be the three possible outcomes you would get from a writ.
I would like just to clarify really quick. You did say you focus on kiddos from 3 to 5 years old, but as IHSS advocates, you do take on clientele that is old, there are older children.
Correct. So we specialize in very young kids. However, we have been successful over the last 10 years in cases from kids as young as 2 all the way up till I have one case where I have a 50-year-old that we got services for. But the vast majority of the cases would fall between the ages, they're school age, so would fall between the ages of age 3 to age 22. And why I say that's school age is because if you're special needs, as a lot of you parents already know, and you are past 18 years old, you still have an additional 4 years of school with an IEP under the school district.
Okay. Elsa asks, what percentage do you collect if you win an appeal?
It's not a percentage. I'm very open and transparent. And so the fee that we actually collect is $11,800. I want to emphasize this, that is less than 4 months of your retroactivity. And so it does sound like it's a lot of money for the fee, but if you do the math on it, the actual benefit for IHSS over a 3-year period is over $100,000. And so, like I mentioned before, this is something that I encourage all parents to try on their own at first, to go through the initial application, to go through the initial assessment, to present your documents, your IEPs, your IPPs, those types of documents, and let the social worker make a determination, because there are some kids that are just obviously needy. They obviously would qualify for the program. But there are other kids that for various reasons are on the fence, and a lot of it has to do with age. And so what we do is when there is a denial from a notice of action, which would come from a social worker, when there's a denial from a social worker, we review your documents to determine if we feel there's a case that could that your matter could be reversed and you could be granted protective supervision with an ALJ. And so that's what we focus on. We really want to encourage the families to start the process themselves, but then if it comes to a point in which some expertise is needed, and that's when you would use an advocate. Thank you, everybody.